I totally agree. I think that generally, as we are looking at the IP technology market in general, it's despite all the global trade tensions, compliance and regulatory difficulties, all these things related to the specifics of one jurisdiction, there are so many angles from which we treat technologies, especially emerging technologies, but just generally many of them as, something that has this global character, something that allows the company to commercialize it in practically every part of the world. And the important thing is how well you protect it from the very beginning, and how well is written your agreement to make sure that you will have the right to enforce it, and to make sure that the agreement that you have with your counterparty is complied with. As we will be probably slowly adjourning our discussion today, I want to ask each of my co-panelists a question as to what do they see as the most highly negotiable and debated provisions in the IP licensing agreements, or IP transfers of different kinds. What is something that you personally sometimes think about and decide as to, like, what is the better approach to suggest to my client? What is the recommendation, in fact, that I, based on my experience, that I would want to offer to my client? What is something that you see as either changing or probably in fact not changing, except for probably one of you will be talking about the price, right? That is definitely one of the things that we all see as highly negotiable, and something that makes people really tough during the negotiation process. But generally, if, for example, it is a result of the litigation, what do you see as the clause that would be, facing most of the clients' aspirations, and having some sort of this highly negotiable character?